Yeah, good to do.
Okay. Yes. So we started video record. This is a training session with Mr. Hennick from the Freedom of Information Act. Thank you so much for joining us and coming to our meeting. We really appreciate it.
Thank you.
So
Thank you for
the floor is
inviting me.
yours.
So first of all, it's Tom, not Mr. Hennick. We'll keep
Okay.
it informal, okay?
Sure.
And second of all, just so you know, we do these sessions on a regular basis. Now, this year obviously has been a lot different. I wish we were actually all together. It's much more fun when we can do them in person. But the truth is, I don't have to drive home tonight, so that's a good thing. Um, we do them not to beat you up, not to make you miserable, not to have you run away screaming. We do them to try to help, to try to give you some information, really to try to give you the tools to work with, so that if you have an FOI issue, an FOI question, you're better equipped to answer it. But you also now have a face to put with the voice on the other end of the phone. As some of you will attest, I will return your phone calls. But we try to help. We try to answer questions, send questions, emails. We want you to try to be able to do things on your own, but we also want to try to help and to try to avoid problems before they occur. Rather than have you call after there's a problem with freedom of information, we want you to sort of get to us beforehand so that we can work some things out. You have a lot of questions, but I'm going to give you just a couple of minutes of an overview, and then we can dive into your questions, and we can stay, as long as you want, but I'm thinking, we can spend an hour or so together, and I hope that'll sort of allay some of your fears and have you feel more comfortable when it comes to freedom of information. You need to remember that freedom of information is a law in the state of Connecticut. It will be 46 years old when we turn the page to 21. And it was Ella Grasso's brainchild when she ran for governor for the first time. And if you do the math, 46 years ago puts us right smack in the middle of Watergate. And you had a country that was in turmoil, a country that was upset by government being conducted in secret, things being conducted behind closed doors. She said, was contemplating the run for governor. She was in Congress, and so she saw all this happen around her. And she said, if I run for governor, one of the first things we're going to do is we're going to create some sort of a law to make sure that what's happening here in Washington that I'm watching does not happen in Connecticut. So she ran and she won November of 74. And one of the first things she did in 1975 was create or put forward, I should say, the concept for this open government law. And said, this is we need to do this to protect the people, to have transparency for our public agencies in Connecticut. And she put it forward, and she really felt it was important, and she pushed it, and she saw to it that this law was approved unanimously by our legislature. I want you to sort of think on that for a second. If you've ever watched the legislature in action, can you imagine? She guaranteed a unanimous vote, and she got it. There was not a single no vote in the House, not a single no vote in the Senate. And again, the law's reason for being, the law's intent is to make sure that people have access to their governmental agencies. And it's about two basic things: access to meetings and access to records. Now, we'll spend most of our time tonight, I suspect, talking about meetings, but it's about both components, and it's about making sure that people have an insight into what their governmental entities are doing. And so then when it comes time to vote on a budget or elect people to boards or commissions, they have something to go on, that they're not operating without knowledge, so that they understand what's going on. I always tell folks one of the things to remember is that it is called freedom of information, but it's not all about free information. It's important to understand that it doesn't give people, a reporter, another citizen, the right to sort of march into one of your meetings and say, I want to tell you this, and I need to know this. Why did you do that? How did that budget come up with this? Why did you do? It's not about answering questions. It's about giving citizens access to the information to make decisions, but it doesn't turn us into their answer men and women, if you will. And some people think that it is. I don't know if it's ever happened to any of you. People, a lot of times, police stations, town halls, they'll walk in and say, under freedom of information, I have a right to know, da 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 da. Well, you might have a right to know, but you've got to do a little bit of the work. It's not about us just sort of spewing forth things. It's about making sure that there's an opportunity for people to see what we do. And I use the word we advisedly, by the way. I was on a board in my town for 10 years. I was the chairman for the last 5. And a couple of years ago, there was a sort of unexpected vacancy on the Board of Selectmen, and I filled that out too. So I've had experience on the other side too. So I understand, what it's like to be living your lives and then go to a meeting and say, well, what's all this freedom of information stuff? Because we're not all necessarily trained to do it. And so that's why sessions like this can be good. And by the way, working at the Freedom of Information Commission, people think that we are an information bureau. I could sort of stop doing the FOI training and tell you stories about people calling us up with, please send me this. They think that we sit in this huge vault with every record held by every agency in the state of Connecticut, and they can call us up and we can send it to them. And periodically I get requests for things that I've never heard of before, and I have to tell them, look, that's not what we do. Or I get phone calls from people. I'll tell you one little anecdote. I took a call a couple months ago from a guy. He says, hey, I need your help. I said, what's the problem, sir? He says, I need a copy of my naturalization papers. And I said, naturalization papers? Isn't that like a federal thing? He said, yes, I went to the feds, but they were going to charge me $500. I thought maybe you might have an extra copy lying around. They think that we're something that we're not. We're about making sure that this law that I'm talking about is properly enforced and that people have the rights that this law. Now, when people believe that they've been denied those rights, and I don't know if any of you are familiar with this portion of what we do, they file a complaint against the public agency with the FOI Commission, which is where I work. So if someone believes that a meeting is improper or records are being withheld improperly, they file a complaint with us against the agency, and ultimately it's our board, our commission's role to see to it that the law is enforced. So you go, if a complaint is ever filed, if you're ever involved in one of those, we have a hearing. If we always try to mediate the complaints, by the way. We have a hearing and the commission says one way or another what you should or shouldn't do. But you can always, just to show you that this law can be sort of complex, FOI commission decisions are appealed sometimes and they go all the way to the state Supreme Court. So we give you an order, that's what you're supposed to do, but if you don't like it, you can challenge it. So I said, access to meetings, access to records. When I talk about meetings, let me give you just some of the basics. It basically means, folks, that anytime you gather to do your work as a board, as a commission, you need to make sure that you've done 3 things, or that you do 3 things, that you notice it properly, that it's open to the public, and that there are minutes of the meeting when the meeting is complete. Proper notice means at least 24 hours in advance, you create an agenda. The agenda you want to make sure is complete, is specific. You have it in your library, you send one to the town clerk, it's available for all to see. Your meeting is open to the public. Now, I'll sort of get off track here for a second because of the world we're living in today, a world I hope that doesn't last, too many months longer. But when COVID hit in March, the governor suspended the requirements for in-person meetings, as you know, and allowed us to do this kind of gathering. But you still have to make sure that you have real-time access to your meetings. So your agenda should also include a Zoom link or a phone number or something like that, so that people can watch your meetings, listen to your meetings as they're going on. And then when that's over, you need to also record them. And then when that's over, the recording needs to be available to the public. Now, again, that is part of, COVID law, Executive Order 7B, I think it is, or 7B. I'm looking at my notes. And that may or may not stay, it may or may not go away, but the bottom line is that's the law as you have it. Real-time access to anybody who wants to participate. Got to remember that there's a couple different kinds of meetings that we use. There's the regular meeting, there's the special meeting. Those are the 2 primary ones for you to worry about. You create a regular meeting schedule. The schedule says that you meet on the 1st and 3rd Tuesday, the 2nd Wednesday, whatever that is, that's your regular meeting slot. Then there's also the special meeting, which is a meeting that you can have when you're not scheduled to meet. The difference between those 2 is minimal. The primary thing is this. At a regular meeting, should something arise that's not on the agenda that you've created, you can vote to add things to the agenda by a 2/3 vote of those board members who are present. At a special meeting, you can't add anything. So whoever prepares the agenda, you know, if we cut and paste a lot when we make agendas, other business, old business, new business, you can use that at a regular meeting. It's not a great item, but at least the chairman can say, is there any other business? And someone can say, yes, Madam Chairman, I'd like to add this. You make a motion, you vote, you add it, you can do that. At a special meeting, you can't. So on a special meeting agenda, if you have something like other business with nothing listed specifically underneath it, you might as well take it off. Because you can't add anything. So you can't say, is there any other business, because it's not specified. That's the primary, those are the two prime meetings that you would use over the course of a year. There are also, you know, different ways that boards and commissions can exclude the public. I suspect if you've been around the block a couple times, you know, there's an executive session. And I think you have some questions about that. We'll get into more specifics on that if you like. And also understand that when we talk about meetings, when you read the definition, there's a phrase in the definition that says whether in person or by means of electronic equipment. So again, post-COVID, you start emailing each other, having conversations via email, don't do it. That would or could become a meeting, and you've basically violated the idea of making sure that your meeting is done in public. I told you I'd only speak for a couple minutes because you do have a lot of questions. Fire away.
Okay, wonderful. Thank you so much. So
Sure.
as you were talking about the types of meetings, so we met a problem. I don't want even to say disagreement. We just don't know really.
Sure.
We don't know where to
But
take
by the way,
information.
When we have these conversations like this, these workshops, or when you call me on the phone, I'm not issuing any orders. These are not commands. This is just advice. This is just to try to help you. This is not, you know, me ordering you to do anything, just so that that's clear.
Sure, absolutely, we understand it. So we have a question about committee meetings, particularly a hiring committee meeting. So if to talk about overall, first of all, about overall committee meetings, it could be policy committee, hiring committee. Are they all on the same stage, or hiring committee is on a different stage?
Okay.
Because
when you have a meeting, if this law applies to all public agencies in the state of Connecticut. It's a long definition. I won't read it to you, but the definition has a phrase in it that says, including any committee of or created by. So if you create a committee, that committee becomes by definition a new public agency. Even though it seems silly, there, you know, maybe only 2 or 3 of you, but that becomes a new public agency that needs to follow the same rules. Now you said hiring. Let me finish the thought, Carrie Ann. It's Karen Ann. And so you said hiring. There is a provision. And, you know, I told you this law wasn't necessarily easy to understand. There is a provision that allows for the creation of an executive level search committee, which does not need to follow freedom of information. So if your board creates a building committee you want to add on to the library, that building committee is subject to freedom of information. A policy committee. But if you are in search of a new director and form an executive level search committee, that committee can operate outside of freedom of information.
Mm-hmm.
Okay, Karen Ann, you had a question.
Yeah, my question was what you just answered, because I had looked it up, because I'm the one who called the hiring committee meeting. And I looked it up and it said it's exempt from the freedom of information.
Executive level positions.
Right. But from what I understand, and I could be wrong on this, if we're discussing personnel, isn't that something that has to be done not publicly as well? If we have personnel issues?
Okay, has to be, that's never the case. But is allowed to be, yes. Now's a good time for me to maybe go over executive session. You've got the hiring committee. Let's call it an executive level search committee. But let's suppose you have situation where we want to talk about the performance of an employee. There's 5 basic reasons for an executive session: a personnel matter, pending claims or pending litigation, a security matter, a real estate transaction, you're going to buy land to expand the library, or the discussion concerning a document or documents that are exempt from disclosure. Let's suppose you put a project out to bid. There's an exemption in the FOI Act that allows you to withhold bids until you've actually signed a contract. So you could go into executive session to talk about the content of those bids until you've actually signed a contract. But Karen Ann, you mentioned personnel. Executive session personnel. Okay, the first thing is this still happens. It's initiated at a public meeting. Your agenda says executive session, discussion of the performance of a library employee. You then need to give that employee notice beforehand. The employee has the right to say, I don't want that to be an executive session. I want it to be public. And if that employee stands by that, you cannot go into executive session. You cannot. But if the employee waives that, you then can vote to go into executive session to talk about the performance of that employee. You go in, you can discuss it till the cows come home. You can have a lengthy discussion. But if you are going to vote under those circumstances or any circumstances, you must come out of executive session to take any action you're going to take. But it should be clear that this is something you are allowed to do. And typically, I don't want to give you the wrong idea, most boards do have those discussions in an executive session, but there's a process, but it's not something that you're required to do. So if you choose to have that conversation in public, you can certainly do it. Go ahead.
Yeah, I guess I just kind of phrased things wrong, because I was under the impression that if the employee was willing to, as we say, let their dirty laundry be aired in public, that it was okay, but if they didn't, then we had to do an executive session.
No,
that's wrong.
You're never required to do that. Now, you may have contracts that require that. You may have board policies that require that, but under FOI only, and that's the only law I can speak to, you're not required to. And it's good policy. It's good, all of that sort of sends you in that direction. But as far as being required, you're not.
Okay, thanks.
All right.
Tom, would you mind
Yes.
going over again the instances where you might use executive
Right.
session? We had
A
personnel, real estate.
Personnel matter,
Okay,
pending claims or pending litigation, a security matter, a real estate transaction. Let's suppose you need to expand and you need to lease space in a building elsewhere in town to expand. And you want to talk about the terms of the lease. You wouldn't have to negotiate that in a public session. So that's sort of the real estate piece. And then the 5th reason would be the discussion of a document or documents that you believe are exempt from disclosure. And I used the bid example a couple minutes ago. Bids are temporarily exempt until you've signed a contract. You ask your attorney for a written legal opinion, and you then become the client. So you want to review that legal opinion to you, the client, and you're not going to share that with anybody else. You could go into executive session because that document itself is exempt from disclosure. Pending claim, I'm skipping around a little bit here, but so the personnel we discussed, pending claims and pending litigation is pretty much what it sounds like. There's a lawsuit, there's a CHRO complaint, there's an FOI complaint. You want to talk about your strategy. You could go into executive session to do that. You wouldn't have to sort of do that in public. The security exemption, unfortunately, has come up more and more as the years have passed since I've joined FOI. But one that's come up more recently is cybersecurity. I've had a couple of school boards have their whole system hacked, and they needed to go into executive session to talk about the measures they were going to take to sort of reestablish security so that they weren't that vulnerable. Those are the kinds of things. So I went over. Does that make sense? So the 5 reasons, are they clear what the 5 different reasons are? Remember, even if the only item you have on a given night or a given afternoon is an executive session item, you must still have an agenda. You must still convene in public, vote to go into executive session by 2/3 of those who are present. In executive session, have your conversation, come out and vote if action is needed, and the vote must be recorded in the minutes, even if there's only the one item is executive session item. While we're talking about keeping the public out, the law, the legislature gave us 2 ways. So executive session outside of the public. Another avenue that boards and commissions can use gets a little complicated, but it just came up before about that executive level search committee. The legislature said, here are some situations that might seem like meetings to you, that might feel like meetings to you. And yeah, they might be meetings, but for the purposes of freedom of information, they are not. The executive level search committee gets taken off the table. I don't know if you have any collective bargaining issues, but when you have collective bargaining sessions, negotiating strategy, those are not covered by freedom of information. Casual gatherings, when you're not talking about official business, although I always chuckle about that. I mean, what the hell else are you going to talk about, right? But you want to, if you're in those circumstances, if you love each other and you're all going out to dinner, make sure that the conversation doesn't get too deep when you're starting to have a conversation about board business. So those sort of 2 divergent paths that bring you outside of the public eye. I saw another question popping up. Yes.
If that's me, I have a lot. So, so as I understood, the hiring committee does not need even to post the agenda. They can just agree in a meeting and meet without even posting agenda.
If it is an executive level search committee, yes. But if you have a general hiring committee that hires all employees, I would suggest that below director, that board should meet otherwise.
Okay. And who calls, we also had a little misunderstanding. Who can call special meeting? If the hiring committee meets, can it be a special meeting? As I understand, any special meeting needs a quorum. And
Hiring committee doesn't need to follow the rules. Hiring committee is on its own. Hiring committee as an executive level search committee isn't bound by freedom of information. So that's up to you. How that hiring committee operates is entirely up to you.
So they can literally discuss everything via email without even meeting. Is it allowed?
Because it is not a meeting under FOI, I would say the answer is yes. Here's the rub. And we have never had a case on this, so don't scream. But there's some question as to whether or not these meetings that are not meetings, if they're held via email or if they're held like this, if you create a record, all records become by definition public records. There's some question as to whether or not those records would be covered. The meeting clearly does not need to be noticed or open, but when you create those emails and do that meeting via email, there's some question as to whether, and I say that in all honesty, it's never been adjudicated, it's not known, but those emails could be subject to disclosure. So you want to be a little more cautious about having those meetings via email, because I just don't know. Karen Ann, yes.
Well, the issue came up simply because I was the one calling the meeting. And I posted it as a special meeting instead of a hiring committee meeting.
Right. And technically you could have just gotten everybody on the phone and said, come to my house, we're going to have a meeting, or, because executive session is one thing, but a hiring committee for executive level, not a meeting.
Okay. So does it matter that I called it a special meeting if it was just a hiring committee?
Only in the confusion that you caused by mistake. Because if someone filed a complaint, here's how I would see it. Someone files a complaint, they had a special meeting, but then they wouldn't let us in. You'd have to say, oops, I didn't realize it wasn't really a special meeting. It was an executive level search committee.
Okay.
I also understand, if that's right, that regular meetings and special meetings, they're supposed to be called by the chair of the board, and the chair is responsible for leading them, for providing agenda, for providing minutes and time. And if that's where I personally had problems, that it will be asked from me and I had nothing to do with it.
Typically, that's the case, but that's not anything that's written or required by the Freedom of Information Act. That is typically more of a local rule. So whatever your bylaws are, whatever you decide you're going to do, however you say you're going to handle it, that's a local issue. That's not anything that we, so in other words, if somebody filed a complaint that the chairman didn't call the meeting, but the meeting was still properly noticed and open to the public, Freedom of Information would have nowhere to go with that. There's nothing in our law that would govern that.
Okay.
So that issue that you just raised is more of a local issue.
And now about, while we're still on the committee meetings, about the quorum. As we forever, as long as I was on the Board of Education, there was a strong requirement that any committee cannot have a quorum. And that was like no quorum, period.
Quorum of
I'm
the
wrong,
full
yeah.
board?
Say it again, sorry.
You're talking about a quorum of the full board?
Quorum of the full board present during the committee meeting. So,
Okay, not true.
okay,
Not true. The committee becomes a separate public agency. Now, let's suppose you have a 7-member board, right?
6,
6-member library board. Okay, so what's a quorum for you?
4.
4. If you have a 4-member subcommittee and designate that as the subcommittee, it gets a little confusing, but that subcommittee notices the meeting of the policy subcommittee, and it's those 4 members. As long as they stick to policy and policy only, that's a whole separate meeting. It's not a problem if you have, more than a quorum on a committee, as long as it's very clear that when they're meeting in committee mode, all they're talking about is their committee work. And they're not sitting there and they're not saying, okay, as long as we're here, let's start working on next year's budget. That would be a problem.
So, but how about, for example, I'm sorry, quick question. How about, for example, I'm a chair of the policy committee. If we meet
Yeah.
4 people, if 4 people meet and we vote on something, then that vote during the policy committee could be looked at as a decision of the board, because, for example, 4 members of the policy committee, what the different.
You still have to bring it to the full board, right? It still has to go to the full board for action. Then all that is a policy committee vote, and that we recommend this and we bring it to the full board.
Okay.
I mean, it's pretty obvious how it's probably going to go, but it's not, you're not endangering anything by doing it that way.
Okay.
Okay.
If you, now, personally, if you have 4 on the, it's you might as well not have a policy committee if you're going to have, 4, but that's up to you. That's entirely up to you how many you have.
Well, I think the issue was that we thought there were 3 on the hiring committee, and a 4th person came in and said, gee, I think I'm supposed to be on here too. So we said, hey, stick around, we'll figure this out later. And so she talked with us. And so we didn't feel as if we had a quorum for the board. Okay, we just felt like we had 4 people in this committee meeting. And we did not make any recommendations that we voted on that were binding. We just recommended that we take something to the full board.
Okay, now you promise, this is one of those situations where it's good that I'm not in person, so you can't throw anything at me. But when you talk about a hiring committee, an executive level, you're calling it I'm executive level search committee, right? That can be the whole board. Quorum, no quorum. I have seen multiple situations where a Board of Education names itself, and there's been court cases about this, by the way. So I'm absolutely rock solid on this one. The board names itself as the search committee for a new superintendent. So the full board meets in the mode without notice, the whole thing, as we talked about with the hiring committee, meets in that mode and does search work. Again, there's a danger that, well, gee, as long as we're here, let's talk about other stuff. And you have to avoid that. But your situation, you could have had the whole board there in that hiring committee because it's doing an entirely separate function. And again, it's critical that you remember that when you're in that mode, when you're having that meeting, because you're basically wearing multiple hats. Now, just to back up the committee. So let's suppose that example with the 4-person committee. The other 2 members come to that committee meeting. They can be there, but they're just like me if I showed up. They're members of the audience. They are not allowed to participate or interact as board members because the committee is an entirely separate board.
Okay,
By definition. Obviously, you all working on the same things, but the board I chaired was a board of education, right? And committee meetings were really critical. They were policy, they were curriculum, they were finance, they were, things, building and grounds. And when a big issue came up, we would meet, the committees would meet, but everybody would show up, and we had to be very careful that they were at arm's length. They could listen, they could raise their hand and ask a question, but they couldn't participate because they weren't members of that committee. Even though they were on the full board, they weren't members of that committee. So you want to be really careful, especially with a smaller group like yours. You just want to be careful how you divvy up the work.
now, would it be fair to say then, a regular meeting, the agenda would have several unrelated items?
Right.
And a special meeting, on an executive level meeting, they should be simply everything related to one discussion.
Special meeting can be about multiple items, no problem.
Okay,
But
Okay.
when your hiring committee is meeting, you're focused only in on the hiring.
okay, that's what I wanted to make
Right. So
sure.
a
Thank you.
special meeting of your board, let's suppose you just, for whatever reason, your regular meeting can't take place on a given night. So you have to have it 3 nights later. Well, that makes it a special meeting because it's not at your regular time. You can talk about everything that's on the agenda. The only thing is you can't add anything to that agenda.
Okay, that makes it clearer. Thank you.
You're welcome. Who's responsible for minutes?
One lady, she is not here.
Okay,
And-
well, you can pass this along to her. Remember, folks, that when we talk about minutes under freedom of information, they need not be the recreation of War and Peace. They are not every word that everybody says. They are not verbatim transcripts. Our strongest recommendation with minutes is a nice, crisp, clear recapitulation of what happens. A record of the votes is all that's really required by law. Now, you want more than that. You're creating your library board's, historical record. You want people to know what you were doing, but how much more is up to you. It's not he said, she said, back and forth. It's a concise sort of capsule of what happened at the meeting. So you want to pass that along.
Absolutely, thank you.
Sure.
Also, back to the committee meetings. For example, we have we have 6 members on the library board, and those 6 members are a part of the hiring committee, for example.
Okay,
And if that hiring committee meets from 6 members, only 3 shows up, we can still hold the meeting.
that's
it's a-
entirely up to you.
because
That's your call.
But because it's a committee, we're allowed to hold the meeting, although there are 6, let it be a policy committee, it doesn't have to be hiring.
Again, to be clear, the hiring committee, let's say it's not the hiring committee. Let's say you have all 6 of you are on the policy committee.
Mhm.
And 3 show up. That's entirely up to you whether or not you consider that a legal meeting. Freedom of information dictates nothing about the quorum, what needs to be a quorum. It's entirely up to you. Oh, hi there. Hope's got company. It's entirely up to you what constitutes a quorum. We don't write that. That's not in our law. So if you say, hey, look, there's only 3 of us here, but we're going to work anyway, and the library board or the town of Wellington says, okay, that's fine. Freedom of information does not dictate what constitutes a meeting.
Okay, back to the same situation. 6 members on the regular board, 6 members or 5 members, for example, on the policy committee. And we voted on something, voted like we agreed on the board. So that's still, even if all 6 members during the policy committee voted on something, we still would have to bring it to the regular meeting.
Mhm.
I
And
would
vote
say
it
yes.
during the regular meeting?
I would say yes, unless the full board, and this, the full board has given the policy committee the authority to make the decision. I would say you have to bring it back to the full board, regardless of how many people are on the committee.
Okay. Okay.
It sounds safer to take it to regular meeting, Elena.
Yeah,
You
so
know?
I just want to know, the extreme situation, so we would all be educated.
Yeah,
Yeah,
think-
the usual, again, it's up to that's another one that's entirely up to you. But typically, the committee makes the decision and then it goes to the full board.
Mhm. Well, as you mentioned minutes, a quick question about minutes. I know the requirement, if there were votes taken during the regular meeting or special meeting, then the minutes must be posted within 48 hours. But,
No. There
no,
needs to be, a record of votes needs to be available in 48 hours. So I would say that somebody gets Debbie a record of the votes and they're in the library, just a record of the votes. The minutes need to be available in 7 days.
okay. So they don't have to be, if we voted, we do not need to post within 48 hours. We can just, somebody
That's
needs
correct.
to know the results. Somebody.
Correct. Correct.
Okay. Okay. So within
Record of
7
votes, 48 hours, minutes, 7 days.
Okay, so if we, for some reason, the secretary or whoever does the minutes is not able to provide the minutes within 7 days, and somebody complains, for example, we had the situations for months delay with COVID. So if somebody would complain to the Freedom of Information Act, what's the result of it? What's the consequences or
The
punishment?
result would be, in all likelihood, now again, I can't make that determination, but my opinion is that in all likelihood that would be declared to be a violation of the FOI Act, and the board would be found in violation.
And
Because
what
the
would,
minutes need to be available in 7 days. If it's an honest mistake, Elena, if it's the secretary took ill or something like that, it would be, folks, you're in violation, don't let it happen again. But if it repeats itself, then the commission could, in theory, order a civil penalty against the minutes taker of anywhere from $20 to $1,000. If it's a meeting situation, the commission can also declare a meeting null and void and say, look, this is ridiculous, go back and do it over again. Those penalties ultimately don't happen very much. You have to be a really egregious violation for that to happen. It's typically, look, you're wrong, do it right next time.
Mhm.
Karen Ann.
If we're in a situation like this, we can record the meeting. If the recording is available, will that cover? Or do actual written minutes have to be available?
You still need written minutes, but I would argue the sort of the scenario, the fact pattern, secretary takes ill and you have a recording but not the minutes. I would argue that the complaint would be far less, any recriminations would be far less under those circumstances. Our commission does not like to be punitive. It really wants to just make sure that the law is followed. That's all.
Okay.
So-
Now, the independence of the executive level search committee, that has to do with minutes too?
Correct.
The search committee, I don't think you want to have public minutes.
See, the reason, some of the things in this law, to be really honest, don't make a ton of sense, but that's one that makes sense when you think about it. When you look for an executive level employee, you want the best. And some people, if the whole thing had to be sort of done in public, might shy away. I'm a superintendent of schools in town A and I'm interested in town B, but I don't want my people at town A to know that I'm looking. So as a search committee, you can hold all that back and do all that in private, so that if the person in town A doesn't get the job, he or she's none the worse for the wear. That's
Okay.
one that really makes sense.
Okay, thank you.
Sure.
So now questions about communicating via email. For example, yeah, that's via email. If one of the board members have a question or suggestion between the scheduled regular meetings, that member, is that member required to send the suggestion or question to the chair only, and chair is obligated to decide whether chair shares, discusses, or whatever the decision, or that member can email to the chair and to all the other members at the same time?
I was about to actually launch into that. Be cautious your use of an email, because the law talks about every time you create a record in the conduct of Willington Library business, it becomes by definition a public record. And in theory, anybody could ask to see it. So what you don't want to do is have a situation where you say, hey, folks, I think ABC, what do you all think? And then you launch a conversation amongst yourselves that you should be having at a meeting. But if I have a question that I want on the agenda and I write to the chair and say, please put this on the agenda, and I copy everybody else, well, that's not a problem. The problem comes when you start having a conversation amongst yourselves. You want to avoid having the deep deliberative conversations amongst yourselves via email or text or telephone that you should be having at a meeting. That's where you run into trouble. So if somebody has a question for the director, a board member wants to ask the director a question, that's not a problem. And copy the other board members, that's not a problem. If the board member wants to express him or herself and say, hey, folks, I feel really strongly about this idea. I really want this to be discussed by all of us. Or even better, I feel very strongly about this. I want to make sure that you all understand this. That's okay too. What you want to do is make sure that it stops there, that when Karen Ann sends this off and says, this is how I feel about this, that Hope and Kathleen don't jump in and say, that's the dumbest thing I've ever heard, and launch an argument or a conversation that you should be having at the table. So you want to share information, you want to disseminate ideas, that's okay. You can do that via email, but just make sure you don't engage, that you don't have the conversations that you should be having at a meeting. You can have agenda conversations, or somebody misses a meeting. What did I miss? You know, something like that. That's certainly okay, but that's the extent to which you want to stop.
Okay. Thank you so much.
All right.
So another question towards the chair's responsibilities. For example, chair receives within the month, receives some letters, finds out some information. Is the chair responsible immediately to share that information, or somebody's or letters, communication with other members, or the chair can choose to leave it for the regular meeting and share it on a regular or special meeting?
That becomes a local decision as well. That's not anything that freedom of information would guide. What you do need to know is when the chair receives a letter like that or a communication like that, as soon as it's in your hands, it becomes by definition a public record and anybody could see it. But when you disseminate it, if you send it to everybody right away, or if you bring it to a meeting, that's not anything that's governed by our law. That's not anything that our law would have any jurisdiction over whatsoever. That's your decision. You have to decide that amongst yourselves.
Mm-hmm. Okay, thank you.
Sure.
So in other words, it's up to the chair. It's totally up to the chair.
Well, it's up to the board. I would say it's up to the board. If the board has a policy that says the chair shall send all communications to every member immediately, then that's what you do. But it's something, if it's an issue, you'd want to discuss it amongst yourselves. That's what you'd want to do.
Okay.
Okay.
Mm-hmm.
So another thing that we should just go over even briefly, you know, I've alluded to it a little bit. When we talk about records, you know, the two components of the FOI Act, access to meetings, access to records. Remember, I said it, when you have a record or when you create a record, it becomes a public record. Now, there are multiple exemptions and there are multiple exceptions to disclosure and all kinds of things like that. But you want to make sure that you understand that you're creating a public record. So, oh, well, I'll just dash off this email. And then somebody makes a request that they want to see any and all emails between, you know, Hope and Kathleen. And maybe it's something that they would have been better off not, you know, discussing via email, because now you've got a public record and they'd have to release it and the world would know what they were talking about. You want to be very careful to the extent that you use it. Again, another little story. I took a call a couple months ago from a woman. She said, "Hi, my name is Sean." I said, "Hi, Sean, how are you?" She said, "Good." She said, "I'm calling you from Georgia." Georgia? Who's calling Connecticut FOI from Georgia? She says, "Yeah, my husband's an out-of-state contractor, and he did a job in Connecticut last summer, and I think he had an affair with a state worker." Why is she calling me? It wasn't me, right? So she says, "Yeah." I said, "She's calling me because she wants to know if she can see that state worker's emails and text messages." So if the email says, "Hi, meet me at the construction trailer at 6 o'clock," we'll review the blueprints, and then, that's a public record because it has to do with the project. She says, "Good, it'll help me with my divorce." Think before you send. Think before you communicate via email, via text, because you could be opening the door to an improper meeting, but also what you're wanting to say could become a public record. Okay. I'm trying to think if there's any other key points that you should be aware of. Anything I didn't touch on? Any questions you want to ask me about? Yes, Debbie.
Hi, Tom. I gotta tell you, makes me fearful of ever saying anything to anybody. But a question, anyways. When it comes to, I have this thing about what can be said, what can't be said, what people should know, what people shouldn't know. I personally don't like to hang out the library's dirty laundry for the whole world to see. When doing things like, because nobody's perfect, we all make mistakes and whatnot. And sometimes that people can use that against you, even if you have the best of intentions. But when it comes to things like our policies and procedures, to go about that, I had read somewheres that it did not have to go before the public until it was finalized. Is it public, like say, I know there's committee meetings, I know there's regular meetings. When you're discussing or want to discuss things as far as going over to revise in any way, make changes, does that have to go before the public? Can it go before the public only after you've decided on what it's going to look like? Do you have to share it when you're going through?
Well, it depends on who the "you" is, Debbie. If
Committee versus yours.
If the chairman turns to Kathleen and says, "Okay, I want you to work on this policy," and then Kathleen comes up with a proposal and brings it to the full board, then the answer to your question is yes. But if you have a policy committee that meets to review a policy, then that's got to be done in public. Because the policy committee would have to notice the meeting and work in public.
What about, we're going to be doing budget pretty soon. Would every budget meeting become open?
Yes, budget meetings are public. They're public. Yes.
Okay.
Yes.
And so then wouldn't the, so if you had a policies and procedure committee, that would be public also?
Yes.
Correct.
Okay, budget and, okay.
So, well, I want to go a little deeper about what Debbie said. So as far as I understand, concerning our library, we had a situation actually for years, for a long time, when the bylaws and policies were not available or nobody knew where they were. So we tried to get them. And we obviously, some of them are very old and need to be changed. But we just can't handle it all at once. So it's a process. So it means that although they are old, they are still our laws. We still have to abide, even if we don't like them. That's our law, and we have to abide under them. And even if we work over something, if we it's still in the process, because we did not accomplish, so we must abide under the previous law, which we have not changed yet.
Again, that's up to you. I have seen boards vote to ignore policy, say, look, the policy from 1926 is outdated. Until we can revise it, I make a motion that we do X, Y, and Z. I've seen boards do that. Again, that's not an FOI decision. That's a decision that you would have to make. You know,
But
if you want to, if you feel you need to adhere strictly to what is there, then that's what you should do. But I have seen times where boards get stuck in this situation that you're outlining and say, this is ridiculous. This policy should have been out of the window 30 years ago, and say this is what we're going to do. And temporarily we're doing this until we have a new policy in place.
But
But that's your call. That's not my call.
in other words, that's a separate official decision of the board to ignore some certain policies. So there has to be a vote taking on the decision saying this and this policy is outdated. We decide to ignore those policies at this until we come out with new ones. So it has
Again,
to
that would be, in my mind, the right way to do it. But our law would not govern that. If you decided to say policy book, we're throwing it out, you're not violating FOI. You're not our law would not cover that. That's
Well,
entirely up to you.
Then that's a little tricky. As I understand that bylaws and policies of the library or any organization, that's a law, which are actually our priority is to follow our bylaws and policies and then state statutes and then Robert's
Wow.
rules.
But if your bylaw contradicts state law, your bylaw is worthless.
No, I understand. It's
Right.
not contradicting. Obviously, we hope we cannot
Right.
know all the
But there are
state
some
statutes.
boards that try to set policies that run counter to what the FOI Act says. And they come to us and they say, but our policy says X, and we say, too bad, our law takes precedence.
Yes.
So if and when you do revise policies, you want to make sure you have state law in mind as well.
So, for example, if the situation comes up, we don't know. We have a lot of outdated policies at this point. So if the situation comes up and we are stuck against that particular policy, we cannot move forward because of some old policy. We have a right, without changing policy, we can just say, hey, that's old, we overrule it, and that's a decision.
That's a local decision, and there's nothing that I know of that says you can't.
Okay. Okay, oh, thank you.
Okay. Any other questions? Anything that I haven't covered that you want me to ask, want me to discuss?
Well, the public participation.
Oh, yes, public participation. You ready for this? Freedom of information does not guarantee anybody the right to participate or speak at a public meeting. Many boards have it in their repertoire, if you will. It's on their agendas, public speaking, public comment, but it's entirely up to you. So how you do that, how you mold it, how long people are allowed to speak, when they're allowed to speak is entirely up to you. Public participation is something that is it's fairly typical, but it's never required under FOI.
Mm-hmm. Okay. So also, as I understand, the agenda for the meeting needs to be posted at least 24 hours prior to the meeting.
Correct.
So, and if public, I met it on multiple occasions when public is very unhappy because it was only 24 hours for different reasons, different boards, not just ours. So we still have it's okay. We don't violate the law by posting it 24 hours prior to the meeting.
But remember that, for instance, if your town hall is closed on a Friday and you're going to have a Monday meeting, you can't slip it under the door Friday when the town hall is closed. You want to have it in there on Thursday because it's got to be hours that the people, 24 hours in the town hall that people could, again, let's pre-COVID or post-COVID could see it.
Oh, hold on. So it means if they post the meeting on Friday, if we post the meeting on Friday 6 p.m.
Yeah,
the meeting is on Monday at 6 p.m.
that's fine.
That's 24 hours.
That's correct.
Yeah, that's what I thought.
Yeah.
Okay.
What else? Any other questions? Any other area?
For example, oh, I got stuck. I have, if that's okay, I can ask another about the public participation overall for our town, for the town. If somebody in the public has a question, can they ask it right away the board chair during the meeting, or they do have a right like to request the public hearing on that particular question?
All right, again.
What's a
requested
public hearing?
Public hearing, that's not FOI. That's entirely up to you.
Uh-huh.
Yeah.
That was my question. Okay.
Yeah. But you know, people, and again, some boards choose to engage people at public meetings. That's not something that I personally find helpful. Someone wants to ask you a question, you say, thank you, we'll take that and we'll answer it at the next meeting, or I'll have the director call you, you know, in a week or something like that. But when you start having a back and forth with somebody at a meeting, I find it to be disruptive.
Mm-hmm.
Okay.
Anyone else has a question?
Anything else? Any other issues? Now, you know what's going to happen, right?
Yes.
As soon as we hang up, you're going to say, oh, I should have asked. Now, I'm not working tomorrow, but after that, just feel free to pick up the phone anytime or send an email. And you need to remember that no question is stupid. This law can be difficult to understand and to navigate, especially if we're not legally trained. I should have mentioned I'm not an attorney. These are not legal answers. This is it'll be 20 years next week that I've been at FOI, believe it or not. So it's based on experience. It's based on what I've seen, what I've learned, but it's not an exact science either. So sometimes things are open to interpretation and we're there to try to help.
Thank you. Well,
welcome.
because as I understand, we are out of questions, but I'd like to ask the public if somebody in the public might have a question.
If
I
there's
think this
anybody
is
there,
Peter.
sure.
Peter, if you have a question, that's your opportunity to ask your questions.
Yes, I do. I do have a question.
Sure.
Tom, in this COVID environment, it's been suggested that for these small meetings, a town committee meeting, for example, that committee can meet in person and the public can have access remotely. That doesn't seem like a consistent standard to me. I would think that it should be one or the other for everyone. Can you comment on that?
Comment would only be an opinion, because the governor's folks, as they've sort of crafted this and sort of cobbled it together, have actually said that that would be okay. That the key is real-time access. So I've seen situations where board members only in the room and everybody else via Zoom or, Google Meets or something like that. I've seen situation where board is in person, the first 10 people who show up can show up, and the law has been stretched to sort of allow that. I happen to agree with you, but I think if a board wants to meet in person, it should go ahead and do that. Again, the numbers being what they are now, this discussion was more pertinent, I think, back in September and October when things seemed to be getting better. The suggestion was go ahead and meet in person, but there are going to be people who don't want to come or still nervous about coming. You should also have the Zoom link available so that people have a choice. That's the advice that we've been giving. So, not either or, but have both available. If you choose to meet in person, that's fine, but anybody who shows up should be allowed to attend. That's the way we framed our answer. That's what we think.
That's good to hear. A follow-up question, if I may.
Sure.
One of the concerns expressed by our selectmen is if 500 people show up to a committee meeting, for example, that would be problematic. But the reality is if we get 2 people at our meetings, it's a major event.
Yeah.
So what you mentioned, that up to 10 people, is that a viable option in the current climate?
Again, I don't know the exact numbers that they're recommending. I think so, but I wouldn't want to be held to that. I'm not 100% sure.
Understood.
Yep.
Thank you.
You're welcome.
Also, I have a question just to clarify for every member. So any member of the board if they have a question, they are allowed to call you. It doesn't have to be a chair or vice chair. Anyone on the board has a right to call you with a question if the question comes up. Yes?
Sure, yes.
I just want everyone to know.
Yes.
Wonderful. Thank you.
Good.
So,
Are we
any
good?
questions?
Think so.
Well, folks, this has been a pleasure. I hope someday we can come out there and do this in person. But again, you've got the face to put with a voice. Don't ever hesitate to pick up the phone. Happy to try to help. Here we are.
Okay.
Yeah, Karen Ann, sure.
I just want to say thank you very much, because as the person who was taking charge of what you called the executive search committee, what we've been calling the hiring.
Yeah,
committee.
that's what it's in the, yeah.
Yeah, I just, I had read things about not having to be public, and I had read other things. Thank you for clarifying. That's all I have
Happy
to
to
say.
do it.
Thank you
Happy to
very
do
much
it.
for clarifying.
Guys, listen, good luck. Happy New Year. May 2021 bring us better days, right?
Yeah.
All right.
Thank
Have a
you,
good
Tom.
evening.
Thank you
Thank
so
you.
much. Thank you. Thank you, Tom.
You're
Thank you,
welcome.
everyone, for
Good
attending.
night.
Good night, everyone.